Hi everyone, in this video we will discuss the intellectual property business as a relevant activity in the economic substance regulations. If you like our content, please click the like button and subscribe to our channel. An intellectual property asset is defined as an intellectual property right on an intangible asset. Some of the examples are copyrights, patents, trademarks, brands and technical know-how. And the business has to earn a separately identifiable income from this IP asset like royalty, license fees, franchisee fees, capital gains or other incomes by exploiting this asset. The important point here is that the income must be separately identifiable. What this essentially means is that if a business is using an IP asset to protect the goods or services it is selling, then it will not be treated as an IP business, as the income is not separately identifiable. The income must be earned directly through this IP asset itself and not by selling the goods or services it is protecting. For an IP business, the core income generating activity depends on what type of IP it is. For instance, in the case of assets like patents, it is research and development activity. All the activities that is done during the research and development from the planning stage to applying the knowledge will be considered as a core income generating activity. In the case of non-trade intangibles, it is activities relating to branding and marketing and distribution. Unlike other relevant activities in ESR, an IP business has a subsection, high risk IP. So what happens if your business is a high risk IP business? By default, the business would have been deemed to have failed the economic substance test and the foreign competent authority will be informed of the business's activities. However, the business still needs to meet the economic substance requirements to make sure that there are no penalties levied on the company. The business should be able to provide evidence of high degree of control over development, enhancement, maintenance, protection and exploitation of the IP asset. The business needs to have adequate full-time staff in the UAE as well. The business should also provide the following information: a business plan for having ownership of this IP asset in UAE, employee informations, and use the above points to prove that the major decision making is happening in the UAE. So how do you know if your business is falling under a high-risk IP business? For your business to fall under a high-risk IP business, it has to meet all of the following three requirements. The first requirement is the licensee should not have created the IP property itself. The second is the licensee should have acquired the IP property from either a group company or in consideration for funding research and development that has been conducted in a foreign jurisdiction. The third requirement is the licensee should have licensed or sold its IP asset to one or more group companies or earn separately identifiable income from a foreign group company with respect to exploiting this particular IP asset. For ESR purposes, an IP business must report to the Ministry of Economy or the relevant authorities in the free zones or financial free zones. I hope this video was useful for you to understand the IP business in a little more detail as a relevant activity in the economic substance regulations. Thank you all for listening.